On your tables is a 2-page handout. There's enough for everybody. It covers the creation of the split estate. Governor Hickenlooper has said that the split estate is the problem causing the conflict in the urban mitigation areas. It's not a problem, it's a fact, and we're going to go through how that happened. And I'm going to read pretty quickly. The 1872 Mining Law and the 1897 Oil Placer Act originally controlled how people prospected, claimed, and developed oil and gas. You could go on any federal land and put a hole in the ground, and the woodchucks were watching you and the squirrels were watching you, but nobody else. There was no regulation. You drill that hole and recover the oil and sell it however you wanted to without any cost to you whatsoever. That was done basically for free. The federal government wanted the development of oil and natural gas later. So, in the first decade of the 20th century, the Navy converted from coal to oil. This was an important progression in creation of the split estate. The Spanish-American War determined this. Coaling a ship required a ship going to a coaling station that had been established by the federal government. That ship then would get loaded with coal by sailors shoveling coal into large bags, and then those bags get hoisted and dumped into bunkers on the ship. There'd be as many as 20 bunkers, 2,000 tons of coal. It'd take 4 or 5 days for this to happen. Sailors in the bottom of the bunkers would spread the coal out with shovels. The coal would top out each bunker, and then the ship would go back to the war effort. In World War I, after this decision was made, a oiling ship could go out into the sea and fuel as many as 34 ships and not leave the war effort. So, that decision was an important part of the split estate. In 1909, President Taft realized that all oil-producing land would soon be privately owned and subsequently reserved millions of acres of land to the federal government to ensure that the Navy would have a supply of oil. Unsure of the constitutionality of his action, he asked Congress to pass the Pickett Act in 1911, which it was not retroactive to 1909, and so there were still claims outstanding out there on land. And the Midwest Oil Company decided to file a claim and pumped 54,000 barrels of oil off that land that the president had reserved or withdrawn. He brought suit, and the Midwest Oil Company lost. In December, in a message to Congress, December 6th, 1910, President Taft said, "As not only the largest owner of oil lands, but as a prospective large consumer of oil by reason of the increasing use of fuel oil by the Navy, the federal government is directly concerned both in encouraging rational development and at the same time ensuring the longest possible life to the oil supply." In 1915, the Supreme Court finally ruled supporting Taft's land withdrawals. The government had argued that military reservations and Indian reservations and bird sanctuaries that the presidents had already set aside had never been challenged by Congress, and therefore they were valid. And so his withdrawal of oil lands was determined valid. Ultimately, that power given to the President was repealed by Congress under the Federal Land Policy and Management Act of 1976. This gave the Secretary of the Interior authority to manage federal land subject to congressional authority to review and modify or revoke their decisions. Finally, in 1916, the Stock Raising Homestead Act, and this is a very important one, provided settlers 640 acres of land in fee-simple ownership for ranching purposes. Unlike previous homestead acts, the 1862 or the 1909, this 1916 act separated surface rights from subsurface rights, with the federal government reserving the subsurface and its minerals to itself. Those of you that are farming and ranching here in Garfield County know that some of your minerals are owned by you, and some of your minerals adjacent to you are owned by the federal government. they've been pooled together and they're producing them that way. It's sometimes an irritation. Now my family, I'm the luckiest guy in the world. I married into oil and gas family. And to talk about how here in this area, my wife's family developed their mineral interests and oil and gas interests, I'm going to go back to the late 19th century, 1893 or thereabouts. There were in Meeker several Englishmen that settled there, and they were interested in developing the oil in the Rangeley. There were visible oil seeps. The names, Tom Leonard, Tom Scott, Reuben Oland, E.E. Fordham, the Pirasols, the Crichelows, and a Chicago hat maker named Perot are some of the names. They formed the Raven Oil Company and the New Union Oil Company. And this group drilled shallow wells in the Mancus Formation beginning in 1893. Between 1893 and 1906, they drilled over 100 such wells, but they were very meager. But they could do it. They could walk onto federal land and they could poke a hole in the ground and make some money without anybody watching over them. In 1908, a promoter who had made good in the Pennsylvania oil fields named C.T. Carney hired A.C. McLaughlin, a geologist from California. McLaughlin quickly recognized Rangeley as the most significant geological structure he had ever seen. In August of 1917, my wife's grandfather was hired to survey the corners on oil placer claims filed by these men. In 1931, a partnership with the Union Pacific Railroad and the California Company, which is now Chevron, was established, and after a year of drilling in the Weber sandstone, showed significant promise. In the meantime, Juan had married E.E. Fordham's daughter, Genevieve, and had filed many claims in the Rangeley field. Fordham was the head clerk at the Meeker Bank and a manager of the General Land Office, which is now the BLM. Fordham hired Juan to survey work for the federal government, and in the pursuit of that work, Juan would file many more placer claims and mining claims on what he thought was worthwhile. He amassed significant acreage throughout the western Colorado and was a prominent wildcatter. The stories about him are endless. The legacy is significant. We're paid on over 11,000 wells, 9,000 of them in Colorado. So, Kirby wanted me to do a little history. That's the history. In 1920, Woodrow Wilson signed the 1920 Mineral Leasing Act. Under this act, the process of mineral development on federal land became a regulated privilege when it had previously been a right. Among other things, the act established the concept of leasing, bonus, royalty, term, and boundary for minerals reserved to the federal government, and granted the General Land Office the authority to regulate. The General Land Office, as I said, is now the BLM. This was not a popular law, and getting it passed was hard-fought. Representative Edwin Taylor, Democrat of Colorado's 4th Congressional District, a native of Glenwood, testified on the House floor that it would result in the development of a huge bureaucracy which would absorb the royalties and expensive administration, would create a host of government employees who could never be pried from their jobs, that tenants would never take as good a care of the property as the owners, that the leasing system involved a heavy loss of taxes to the states and the counties of the West, that it deprived the Western people of their freedom, compelling them to surrender the sovereign right of American citizens to local self-government and become permanently helpless, if not servile, tenants under federal tyrants and autocratic predatory bureaucrats. An outrage upon a free people. A Democrat. The irony. So the subsurface mineral estate became marketable. Minerals owned in fee simple and federally owned minerals were leased, traded, bargained for, and sold. Minerals are auctioned for development and are used as collateral in financial markets. For the agricultural community, they go and get loans to do the work that they're going to do the next year based on the value of the minerals that are being produced on their land. It's very important to them. Ownership of minerals has over time become fractionalized, and probates and bargaining through bargaining, and lawyers versed in title search write well title opinions before a well is drilled so that the owners of the royalty interests are identified, division of interest orders are issued to those owners so that they can verify the portion of the well's production that they own, and royalty payment due to them. I'm really going fast because we don't have a lot of time, but I'm going to get to the conflict. Real estate developments that abut rural America have been acquired from these farmers and ranchers. Many times these farmers and ranchers sell the surface of the land but reserve the mineral estate to themselves, and they expect to reap the benefit of that ownership in the future. Now, with valuable minerals underlying home sites, we have conflict. Often Governor Hickenlooper refers to the split estate as a problem that has caused the conflicts. I wish he'd stop calling the split estate a problem. Problems have solutions. The split estate is an immutable fact. Court decisions support its legitimacy and provide for access across surface lands to develop it. It is a real property right with significant value. The split estate serves an overlooked economic purpose in land development. By reserving the minerals to themselves when selling to a developer, the developer's economic barrier to enter the marketplace is significantly reduced. Last year, our chapter commissioned Netherlands Sewell to perform a valuation of what revenue might be produced in a 640-acre section of the Niobrara Formation in eastern Boulder County. The numbers are staggering, and doing a little arithmetic to reduce it to the mineral value under a quarter-acre lot plus the leasing bonus that would be paid if a developer would have to pay a little over $250,000 extra per lot. This was based on 16 wells drilled in 640 acres, and we all know that technology and practice allows for many more wells than that. That brings us to the subject of inverse condemnation by regulatory taking. There is very little case law on this as applied to oil and gas. I believe that the one lawsuit in Michigan yielded a judgment of $14 million for a very small acreage. The governor has said it would cost the state billions. He underestimates. And of course, we all await the ruling of our own Supreme Court in the Longmont and Fort Collins lawsuits. If those lawsuits provide for bans and moratoriums, then we go to the federal courts and we recoup the money that has been taken. All of the states have signed a compact, a treaty, establishing the Interstate Oil and Gas Compact Commission. The commission has written a model act. The model act is what the states use to write their own oil and gas acts, and they can modify it and add to it and harmonize it with the state law. One paragraph from the commission charter is interesting. The commission shall have the power to recommend the coordination of the exercise of the police powers of the several states within their several jurisdictions to promote the maximum ultimate recovery from the petroleum reserves of said states, and to recommend measures for the maximum ultimate recovery of oil and gas. Said commission shall organize and adopt suitable rules and regulations for the conduct of its business. A compact or a treaty between the states supersedes the United States Constitution unless Congress repeals it. So that brings me to answering the title premise of this presentation: are mineral and royalty interest owners the forgotten factor in oil and gas development? Well, the industry's not forgotten us. They write us checks. But it seems the public is not quite as savvy as they were in the 20th century. So those of you with jurisdictional planning authority really have a duty to inform your constituents when faced with these conflicts. Mineral owners and royalty interest owners who might be charities, religious organizations, banks, family trusts, limited liability entities, private investors, retirees, individuals who live in other states, and all manner of entities that do not have a right to vote are invisible to you. Those citizens who do vote for you are in your face. Mineral estate owners are rarely seen. We must rely on the state with its police powers to protect our rights. Failing that, then it is the federal government and the Constitution we will turn to. Please do not forget us when you make your planning and zoning decisions. Any questions? Some people ask how minerals get valued. Petroleum engineers who have gone to school to understand how to value that, do that work. That's where I referred to Netherlands Sewell. They are appraisers, but different sorts of appraisers than what you're normally used to, and they operate under Security and Exchange Commission rules and the IRS rules, because a lot of times they're doing valuations based on probates, and it really affects our value and how that happens. It was just a fact that I thought you might like to know. And I am finished. Is there time for a little video, or?
We better go on.
Okay, that's fine. Thank you all.